So this time what I want to do is talk about some of the most important jurisprudential concepts. And where am I going to start? Well, where else would I start? With all the science fiction that I used to read when I was a kid. I'm not sure how many of you would recognize Isaac Asimov now. He was a prolific and really, really famous science fiction writer. His stories have been, short stories and long form stories, have been turned into many a movie. Some of them you might recognize. I know Robin Williams and Will Smith have both starred in movies based on Asimov's stories, and many of his stories were built around what he referred to as the three laws of robotics. So I'll talk about what those laws are shortly, but yeah, we're going to talk about Asimov's laws. Now, I don't want to put too fine a point on it, but clearly Asimov is not a legal scholar. His laws were a construct of fiction. They often provided an opportunity for storytelling when there was a conflict or an issue between the laws. But they've been referred to so many times in various different writings about what the ethics of artificial intelligence should be. I think it's worth our while actually just reminding ourselves about them. So the three laws are pretty simple. Actually, I've got a whole separate slide on what the laws are. I'm going to come to that in a minute. The second I wanted to remind you about, we talked about in week 1, I think, is Lawrence Lessig and his argument that ultimately code is law, that ultimately the decision-making processes that are inbuilt into artificial intelligence or inbuilt into the code itself ultimately will determine the way in which AI behaves, and accordingly the code itself is, by extrapolation, the best process for regulating the way that AI exists. This is a thought that we will come back to over and over again. And then last week I did mention briefly the work from American legal theorist Lon L. Fuller, and the morality of law. And again, I've got a separate slide on what those processes are, but I think the kind of minimal conditions provide as good a framework as any against which we might analyse what legal considerations need to take place when we're thinking about artificial intelligence. But before we can even really think too much about what the laws should be, I want to distinguish very quickly between legal ethics and laws themselves. So when we talk about the law, we're referring to a system of rules or regulations that can be enforced by government institutions, for example, courts or the police or the army even. Laws are established to maintain order, to protect the rights of individuals, and ultimately for providing frameworks for resolving disputes. In class, we've talked about public laws that apply to all people, regardless of who they are, if there is appropriate jurisdiction. Remember back to week 1 when we talked about what jurisdiction was and how a state has a range of different jurisdictions to enforce and to adjudicate. So we also talked last in class about private laws. So private laws are the laws that you and I might make about the way that we govern our mutual behaviour. So a contract is a really good example of a private law. And so regardless, now I'm vastly oversimplifying that distinction, but a law is essentially something that can be enforced. When we talk about ethics, on the other hand, what we're talking about is a set of moral principles and values that will guide an individual's behaviour and their decision making. So ethics might be, but they're not necessarily enforced by legal systems. Instead, they're shaped by society, so societal norms, cultural values, and of course your personal beliefs. Ethics can vary across different cultures and contexts, and what's considered ethical in one situation may not be in another. What was considered ethical and right at one time may not be at a different time. In the context of business in particular, laws typically dictate what actions are legal or illegal, while ethics guide what actions are morally right or wrong. So as the quote on the slide says, ethics is knowing the difference between what you have a right to do and what is right to do. Of course, people have personal ethics that are driven by a range of different things, and two people in the same situation may not have the same ethical standpoint. Similarly with companies. So actually, let me give you an example in business that's used all the time. A company might be legally allowed to take advantage of a loophole in a tax code in order to minimize their tax burden, but it may not be considered ethical to do that if it means avoiding their fair share of taxes. Or let's use an AI example. So artificially intelligent powered facial recognition systems are used to identify potential customers for targeted advertising. From a legal standpoint, a company needs to comply with a range of laws. So if they're in Europe, for example, and they're using facial recognition systems, AI-powered facial recognition systems to identify people who might be good targets for their particular advertising billboards as they walk past them through. The GDPR, the General Data Protection Regulations in Europe, or similar in the US, the California Consumer Privacy Act, for example, will govern the ways that they can collect, store, use the personal data, including facial images. So a company needs to ensure that their facial recognition system is collecting and processing the data in the ways that complies with the relevant laws. In Australia, if the company's turnover is greater than $3 million, similar, not exactly the same, but similar rules will apply. But that's the legal position. From an ethical standpoint, the use of facial recognition can raise all sorts of concerns about privacy, about discrimination. AI systems might not be always accurate in recognizing individuals from different races or genders, and this can lead to bias in the way that the advertising is targeted. Also, the collection and the storage of the images without consent can be seen as a violation of somebody's privacy. So while the use of AI-powered facial recognition can be legal, it's got to be important to consider whether it's also ethical. And the ethical norms, the society values, ultimately will impact the way that governments and lawmakers think about what a good law should be and how that technology should be regulated. So when there is a law, there is an incentive for companies to ensure that the technology is compliant with that law. So there might be minimum standards of security, there might be requirements to ensure that the technology works in an accurate way, or that it's unbiased, or that people's consent is collected in some way. And so basically there are different impacts depending on when we're just talking about what you have the right to do or what is the right thing to do. So why is it that we keep coming across these fictional rules, these Asimov rules, in the reading, in online, in our discussions about AI? And I think really it's like, even though these were fictional approach to dealing with this problem, and they're really kind of an artistic construct more than anything else. They were one of the first times in popular literature anyway, that people started to think about questions about what the world might look like in the event that machines obtain some kind of autonomy. As long ago as 1991, another science fiction writer, but also legal theorist or ethical theorist, Robert Sawyer, was writing about the ways that that ethics is relevant to artificial intelligence. He was even commissioned to write an article for Science, one of the most well-regarded science journals, about this very question back in 2007. But as early as 1991, in an essay, Sawyer wrote about the extent to which the development of artificial intelligence is a business. And as businesses are notoriously uninterested in fundamental safeguards, especially philosophical ones, he was arguing that there is a responsibility of the law or governance to ensure that there is appropriate regulation. So the kind of examples he used were the tobacco industry, the automotive industry, the nuclear industry. Essentially, none of these have ever, according to Sawyer anyway, from the outset started off with the argument, we need fundamental safeguards. These are necessary. Every one of them has resisted externally imposed safeguards, and none has ever accepted an absolute edict against ever causing harm to humans. And so this is the argument, in a sense, for why it is that we need to be developing laws that deal with the questions of autonomous machines. So the first time that we saw a rule of this kind, or sorry, if we saw Asimov's rule, was in a short story in the book I, Robot, which, yeah, again, Will Smith, what's not to love? Actually, he's a bit cancelled these days, isn't he? But anyway, I loved him in that movie. So what are these three rules? So the first one is that a robot may not injure a human being or through inaction allow a human being to come to harm. The second, that a robot must obey the orders given to it by a human, except for where such orders would conflict with the first law. And then thirdly, a robot must protect its own existence as long as such protection doesn't conflict with rules 1 or 2. Subsequently, he came up with this idea of the zeroth law, and the idea of calling it zeroth law was that it sat above law number 1, so each of them rank in superiority, lower numbers outrank higher numbers. And the zeroth rule said that robots needed to protect humanity generally. Now, immediately we can see conflicts with these laws. Think about autonomous weapons. So if an army has created a drone, which the purpose of that drone is to go and seek out individuals in a country that the army is at war with, and kill them, ordering a machine to go and do that would be a breach of the first law, and that second law would say that the machine doesn't have to follow that order. And really, we can see that these rules are in part, they're a literary device. We set up a universe where these are the rules, and then basically the stories come out of the spaces where these rules conflict with each other. Now, it's important to remember that robots and artificial intelligence don't have to obey these laws at all, right? These are fiction. And at the end of the day, any law that is created will only follow the rules that are created for it if they are programmed to do so. So we've got robots around all over the place. So think about it. any of you got one of those little Roomba carpet things? I think my dog would have a fit if I had one. But you know, they go around and they map the place, and they find dirt on your carpet and they vacuum it up. Yay, what's not to love? Um, but they don't have any ability to know that if they ram a person's ankle as opposed to the side of a chair, that they're going to cause pain when they do so. And they won't necessarily know how to stop in doing so. Um, Many autonomous machines now are constructed with physical safeguards, so bumpers, warning beepers, safety cages, restricted access zones, in order to prevent accidents. But all of those things need to be programmed in. They're not capable of understanding these three rules or any other kind of rules at this stage. So, what kind of rules, once we've identified what these rules are, what kind of rules do you think that we need to have? So this brings us to the next thing that I wanted to talk about, which is reminding you of Lon L. Fuller's features of a good rule. We talked about a few of them last time. There are 8 principles in a nutshell. So the first is that rules, genuine laws, need to be sufficiently general. So in other words, a rule that applies to all AI as opposed to AI that is developed by Microsoft. So if we were to have a law that just related to ChatGPT, then even though at the moment that's the only thing that is being talked about, it's not the only thing that does what it does, but it's the only thing that's being talked about, that would be too specific, because it actually wouldn't stop people from just doing the same thing under another name. It needs to be publicly promulgated. In other words, it needs to actually be a known law. It can't be a secret. It needs to be prospective. We shouldn't be creating laws that, genuine laws, don't dive back and say, you did this thing in the past, and even though there was no law at the time that meant that you shouldn't have done it, we're going to make this law retrospective. We're going to make it retroactive, and it's going to apply anyway. I love this. It's so legal. It needs to be at least minimally clear and intelligible. In other words, people need to understand what the law is. Now, at least minimally clear is, we're wordsmithing here, aren't we? It's not a particularly clear statement, at least minimally clear. So what Fuller is saying, sure, 6-year-olds don't necessarily need to be able to understand it, but it should still be sufficiently clear that lawyers can make sense of it, and that business people can recognize that there is a law there and have some chance of making sense of it. It should be free of contradictions. Sorry, I am umming and ahhing all over the place. It must be very annoying for you. I should use some AI to delete those ums and ahs, shouldn't I? So it needs to be, and this is kind of the other side of the next one, relatively constant. So it needs to be free of contradictions. In other words, we can't have one law that is the opposite of another law and both of them stand up together. There needs to be a way of addressing inconsistencies and to ensure that the law applies consistently across the population. It needs to be relatively constant. It is not useful and it is not easy to deal in a jurisdiction where the law changes regularly. One of the key ways that companies attract business, international business, is by providing or minimizing what we call sovereign risk and providing a constant and fair legal landscape that means that businesses and entities that make investment in doing business in a place, that you're minimizing the risk that that they're going to be able to make profits in the way that they expect to make profits, to do business in the way they expect to do business. They need to be, the seventh one is they need to be possible to obey. So setting a rule that requires everybody, if anybody, let's make up a silly one. If the rule is only those people who can scale a 10-foot wall unassisted can vote, it's quite likely that I would not be able to vote. I'm quite short and I'm not very good at climbing things. And I don't think I would be alone in that. So we would end up with only elite, say, members of the police and the army able to vote. Is that really a good law? And then the last one is that the law itself should be administered in a way that doesn't wildly diverge from their obvious or apparent meanings. In other words, we should be able, it's a little bit going back to at least minimally clear and intelligible. But this is about making sure that laws are applied consistently and not precociously, that we're not finding these tiny little rules that limit people's ability to live their lives, or to enjoy their freedom, or to do business. So Fuller calls these the principles of legality, and together he argues that they will guarantee that all laws will embody certain moral standards of respect, fairness and predictability that constitute important aspects of the rule of law. So notice there that this is like an ethical framework for building regulations. So coming towards the end of this particular part of our discussion, I just want to point out the two chapters that you have been asked to read this week. There's one from George Borges and the other from Anthony Wong. Now, they cover similar but slightly different issues. So George Borges in particular talks about the base tenets of a regulatory systems and how they were created well before many of the technologies that we take for granted these days were even thought of. He looks at the new technologies and the new opportunities and new risks, and thinks about the ways in which legal considerations can take into account balancing opportunities and minimizing risk. Anthony Wong looks at some sector-specific regulation that's been adopted and adapted to address the market failures and risks in critical and regulated domains. So particularly in fintech. So this is relevant in relation to the Financial Services Royal Commission that was held in the last couple of years. He talks about the ways that laws have often been developed reactively and in a piecemeal way, with artificial delineation of rights and responsibilities. And as a consequence, we've got unintended consequences. So as we think about those approaches, we're going to look, particularly this week, at autonomy, at trust and transparency, legal personality and capacity, intellectual property and other forms of ownership, and a little bit at law enforcement. While both of your readings cover it, they talk quite a bit about liability. This is something to shelve that, read it anyway. It's useful to you for next week. And we'll really focus in on liability for autonomous systems as a much deeper dive next week. So in the Borges reading, you're going to see particularly questions about intellectual property, so the creative efforts of autonomous systems. It's going to look at autonomy and ownership, autonomy and legal personal capacity, but talking about declarations of intent and contracts. And he also explores a little bit about the opportunity for new legal instruments when thinking about legal personality. And in the Anthony Wong reading, again, he's really focusing on the ways that regulation might need to be recalibrated and adapted to address new opportunities and risks. So the big questions he's talking about are how much autonomy Should artificial intelligence or robots have to make decisions on our behalf about our lives, our work, and the way that we even do our recreation? How do we ensure trustworthiness? And in order to do that, do they need to be transparent, reliable, accountable? And does that need to be part of the way that they're designed? The kind of legal considerations he'll focus on are employment law implications, the question of ownership of the underlying data that fuels artificial intelligence. As I mentioned before, he's going to talk about legal personhood or legal personality and capacity, and of course the transparency and explainability of AI. So basically that's where we're finishing for this particular extract, and I wanted to start talking about that autonomy and legal personality in the next video or podcast. Questions, concerns, frustrations, or compliments, you know where to find me. Cheers.